Justices Mawhorr, Brookman, Tavitas, and Ochawa presiding. Be seated.
Good evening and welcome to the finals for the 31st Wabash College Moot Court competition. This event is co-sponsored by the Rhetoric Department and the Wabash Club of Indianapolis. My name is Jeff Drury. I'm chair and professor in the Rhetoric Department and this year's campus organizer of Moot Court. At this point, I'd ask that you please make sure your cell phone is turned off or silent so that we don't interrupt the court proceeding. For those unfamiliar with Moot Court, the competition at Wabash simulates an oral argument at the Supreme Court of the United States. We generate a fictional case, but it's related to a real legal question. This year's case, in a nutshell, concerns whether state laws that ban the use of surgery, puberty blockers, or hormone treatments as gender-affirming care for minors violate the 14th Amendment of the U.S. Constitution. Now that sounds fairly straightforward, but I promise you it is not that straightforward. You'll soon see that it's much more complicated and that the advocates in front of you have been thinking a whole lot about this over the last 3 or so weeks. They received the case documents on October 2nd, and then this past Saturday they showed up at 8:30 a.m. in the morning to argue both sides, and then they also argued another time as semifinalists on Monday evening. The final 4 of the 32 who won the competition stand before you this evening. Before I introduce the advocates, I first want to thank all of the students, alumni, faculty, staff, and community members that were involved in this year's competition. I especially acknowledge Scott Himsel, John Pachter, Matt Griffith, Adam Alexander, and case writer Jane Ann Himsel for their dedication to Moot Court. Isaac Morrison, class of 2026, and Luis Rivera, class of 2025, were instrumental as student assistants on Saturday. Numerous staff, including Julia Phipps, Amber King, Alumni and Parent Relations, Bon Appetit, Campus Services, and others helped make this event possible. And finally, Moot Court enjoys generous financial support from the Rhetoric Department, the Wabash Club of Indianapolis, Bruce McGarr, class of 1972, and Jason Jackson, class of 1997. A full list of acknowledgments is in John Pachter's excellent program book that you likely received when you arrived. Please join me in recognizing all these people for their hard work. Our agenda this evening is as follows. I will first have the privilege of introducing our student advocates in their speaking order. Then Professor Scott Himsel will introduce our judge panel. Each speaker will then have 12 minutes to present his case. During this 12 minutes, the judges will interrupt as they wish to ask questions, and then the advocates will be encouraged and required basically to answer those questions. Following the oral argument, the judges will adjourn and confer before they come out and announce the top advocate, and then we'll award the Floyd Prize in Artful Advocacy. After that, the participants will take a photo or two, and then we'll meet you in Littell Lobby for a reception. So on to our student competitors. Tonight, Tobey Condon and Elijah Wetzel represent the Petitioners, the minors and parents seeking gender-affirming care in the appeal. Elijah Wetzel is a sophomore from Lafayette, Indiana. He intends to major in religion with minors in political science and global health. He's secretary of the Pre-Law Society, a writer for The Bachelor, a peer writing consultant, and active with Lambda Chi Alpha and the Wabash Student Senate. Following Wabash, he intends to pursue law school with the goal of being a litigator. A main lesson Elijah took from his experience this year is that, and I quote, "there is no substitute for preparation." Tobey Condon is a junior from Watervliet, New York. I think I still messed it up. He coached me on it, and I still got it wrong. Watervliet, New York. He is a PPA major with a classics minor. He's vice president of his fraternity, Phi Kappa Psi, involved in the Pre-Law Society, and works as a digital projects assistant for the Lilly Library Ramsey Archives. After Wabash, he's interested in going to law school as well, or possibly graduate school. And he's found that Moot Court really underscores the importance of critical thinking and meaningful results-driven discourse for civil society. Please join me in congratulating Elijah and Tobey. Jake Weber and Gabe Pirtle behind me represent the respondents, or the state, in this appeal. Jake Weber is a senior from Fishers, Indiana. He's a double major in rhetoric and French with a minor in political science. He's currently president of Tau Kappa Epsilon, secretary of the Sphinx Club, a senior fellow with Wabash Democracy and Public Discourse, a member of the Student Senate and Glee Club, and a peer tutor for writing and speech. Jake wants to attend law school after Wabash. Are we noticing a trend? He appreciates how Moot Court has helped him to be an advocate, even when he personally disagrees with the side he's arguing. And Gabe Pirtle is a senior from Sullivan, Indiana. He is a PPE major and classics minor. He lives in Martindale Hall and is treasurer of the Pre-Law Society. He's also a justice of the Wabash College Supreme Court. Gabe plans to attend law school after Wabash. He commented that it's been both difficult and rewarding to explore complex issues through the Moot Court competition. Congratulations to Gabe and Jake. At this point, I will turn the podium to Professor Scott Himsel, class of 1985, who's a campus co-organizer with me and Wabash College's pre-law advisor, and he'll introduce our finals and judge panel.
It's my pleasure to introduce our panel of distinguished judges tonight. Serving as our Chief Justice is the Honorable Matthew Brookman, a federal judge who serves in the United States District Court for the Southern District of Indiana, resident in the court's Evansville, Indiana division. Judge Brookman received his bachelor's degree from DePaul University, where he was an active member of Phi Delta Theta fraternity. He received his law degree from Washington University in St. Louis. Before assuming his current position, Judge Brookman served as a United States magistrate judge and as an assistant United States attorney. I should add that his son, Adam Brookman, graduated from Wabash College in 2023 and is currently a law student at Indiana University. Thank you for leading us tonight, Judge Brookman. Our next panelist is the Honorable Elizabeth Tavitas, a judge on the Indiana Court of Appeals in Indianapolis. Judge Tavitas received both her bachelor's degree and her law degree from the University of Notre Dame. Prior to joining the Court of Appeals, Judge Tavitas had a wide-ranging career in the law, serving as judge of the Superior Court of Lake County, a deputy prosecutor in Lake County, a juvenile public defender in Lake County, and in private practice. Thank you so much for joining us, Judge. We appreciate it. We also welcome to Wabash for the first time tonight our next panelist, Ms. Christiana Ochoa, Dean and Herman B. Wells Endowed Professor of Law at the IU Mawhorr School of Law in Bloomington. Dean Ochoa received her bachelor's degree at the University of Michigan and her law degree from Harvard University. Her research has sought to understand how economic activity impacts human and ecological well-being. She also practiced law with the global law firm Clifford Chance and with a number of human rights and humanitarian non-governmental organizations in Latin America. Dean Ochoa, we appreciate very much your service on our panel tonight. Our final panelist is the Honorable Douglas Mawhorr, a judge of the Delaware Circuit Court in Muncie, Indiana. Judge Mawhorr received his bachelor's degree here at Wabash College, where he was an active member of Kappa Sigma fraternity. He began his legal career before he attended law school while working as a paralegal in Washington, D.C. and in Fort Wayne. He received his law degree at IU Mawhorr School of Law. Before taking the bench, Judge Mawhorr was engaged in the private practice of law in Franklin, Indiana, and in Muncie. He also served as a deputy prosecutor. Welcome home to Wabash, Judge Mawhorr. We are so happy to have you back.
Good evening, everyone. We'll call the case of T. Oak et al. Versus William Elm, Attorney General from the state of Red, et al. Begin arguments tonight with counsel for petitioner. Let me take the podium.
Thank you, Your Honor. May it please the court. My name is Elijah Wetzel, and along with my co-counsel, we represent petitioners in this case, T. Oak, John Doe, Ryan Rowe, and their parents. We're here today because Red State's Senate Bill 1 denies life-saving treatment to minors based on their nonconformity with Red State's gender stereotypes. We respectfully ask this court to reverse the 14th Circuit's decision for two main reasons. First, SB 1 discriminates against transgender minors, and therefore it is subject to intermediate scrutiny, which it fails. Second, Bostock and Smith control this case. Senate Bill 1 discriminates against transgender minors by affording cisgender minors a treatment that is unavailable to transgender youth. This is a classification based on gender stereotypes, which means, as JEB versus Alabama instructs, heightened scrutiny applies.
Counsel, doesn't the act apply equally to both sexes?
It does, but it discriminates based on gender nonconformity. And simple equal application, as this court ruled in Loving v. Virginia, doesn't automatically mean that the parties are equal. The notion that discriminating against both parties in a situation makes them equal and rids the situation of discrimination is false. Double discrimination.
But can't you have rules or laws that distinguish between men and women?
Well,
I mean,
yes.
you let men into women's bathrooms, there's laws against that. Why can't there be laws dealing with children's sex?
Your Honor, indeed, we do have to recognize that, as Justice Ginsburg put it in the Virginia Military Institute, enduring physical differences between men and women is not discrimination, as you say. But this fact does not make any law that references men's and women's biological differences free from heightened scrutiny. This act goes further than just recognizing biological differences between males and females. It prohibits, based on a minor's sex and gender conformity.
Are there any other laws that regulate medical treatment for children?
There are. Yes, there are.
Can you tell us what those are?
There are laws that regulate children's access to off-label drugs, that regulate children's access to certain types of procedures that only adults can achieve. But in this case, the discrimination is not against a child just because they're a child. It goes further than just stopping at age.
Wait. Adults can get these procedures, but the kids can't. So it is because of children.
Adults can get this treatment, Your Honor, but I'd like to point to Red's stated interest in this case. It's not because the children are minors. That they do stipulate age in the act, but Red State's stated interest is prohibiting medical procedures that seek to enable a minor to identify with or live as a purported identity inconsistent with the minor's sex. The true thrust of this act is at transgender youth, preventing them from living in a gender that the state simply doesn't agree with.
So is the issue regulating, is the medical regulation mental or physical?
The medical regulation here, I think
Does it make a difference?
I would not say that it makes a difference, Your Honor, in this case. And Red State's purported interest that they assert in regulating the public health of minors is just, as we can see in Weinberger versus Weisenfield, a mere recitation of a benign purpose, like they have here, which is to regulate the public health of minors, does not automatically remove the true reality of what's at play here. And under SB 1, a person identified as a male at birth could take testosterone to conform to a male identity, but a person identified as a female at birth cannot. This sex discrimination subjects SB 1 to heightened review, namely intermediate scrutiny, where a law must be substantially related to an important government objective. Under this standard, the burden rests entirely on the government to come forward with an exceedingly persuasive justification for the sex classification.
So what about the parents' rights to choose for medical treatment for their children? Are you arguing with the parents as well?
Yes, Your Honor.
And what are their rights?
Their rights are to obtain reasonably banned medical treatments for their children. And the state here clearly infringes on that. And on the equal protection point, the Act stereotypes based on a minor's sex as a sign of birth. And these treatments that affirm a minor's gender and that are available to them are banned for a minor of the opposite sex when they seek to use the treatments for the exact same purpose. These treatments reduce rates of depression, anxiety, self-harm, and suicidality in transgender minors. And they have infrequent and easily managed side effects. And they are safe
for that assertion. Can you cite the basis for that assertion?
The basis for the
assertion that transgender transition care minimizes the psychological impacts that you described.
I believe it's on, I don't have the exact page number to you, to cite to you back. I think it should be around between pages 20 and 23. It's in the WPATH guidelines section in the part of the record on gender dysphoria for the petitioners. But to get back to my point, there's the benefits of these treatments are wide-ranging, and they're banned for the children that really need them most. Like Teoke, who developed a UTI when she didn't have the care that she needed. Or Ryan Rowe, who had panic attacks and stopped speaking in public when he didn't have access to this care. Ryan Rowe went through 2 years of psychotherapy that did nothing to solve.
You just said that they're banned for the children who need them most. Can you elaborate on that a bit? Aren't they banned for all children?
They're banned for all children, but the children who are seeking out this treatment for transitioning are going to be the transgender youth. And for the minors that want to conform to their gender that they were assigned as their sex at birth, this treatment is still open to them. And recognize, at the most basic level, males can take hormones to look more stereotypically male, but females cannot, and vice versa.
Mr. Wetzel, the treatments you're talking about that red state wants to ban, are they permanent? I mean, do they not last forever?
They are irreversible, as respondents assert, although they don't support that in the record with any evidence further than just asserting they're irreversible.
Is that your position, that they are permanent and not reversible?
I think we would accept that statement of the facts, but I point out that on the opposite side, puberty is also an irreversible process. So there's this tightrope in between the irreversibility of the treatment and then the irreversibility of puberty. To side with the irreversibility on the treatment point of view is to throw aside the 99% of cases in which minors who receive this care do not regret it, and the 1% that they do. And I'll turn now to the intermediate scrutiny point. The government.
Before you go there, let me ask you a question. If you prevail in your argument here this evening, would it have the unintended consequence, perhaps, of rendering invalid the laws in the 14 states that have passed laws to protect gender-affirming care?
No, Your Honor, I don't think it would. And the government's stated interest, which I read before, is purely discriminatory and would subject thousands of children, just like today's plaintiffs, to a litany of serious and potentially lethal health outcomes, including, as I said before, high rates of anxiety and depression, eating disorders, substance abuse issues, self-harm, and suicide. And red state never give an exceedingly persuasive justification for this. And the Act also fails on rational basis review. The bar for rational basis review is on the floor.
Those are very grave outcomes. So can you describe the state's interest in regulating transgender care for you, given those grave outcomes that you just described?
The grave outcomes, if untreated.
Can you describe the state's interest in regulating transgender care for you?
The state's interest, they claim, is to, in the Act, is to is to prohibit medical procedures that seek to enable a minor to identify with or live as a purported identity inconsistent with the minor's sex. That language is within the,
Sorry.
That language is within the-
I understand that's a language inside the statute. I'm asking you to describe the state's interest in prescribing transgender care of this sort.
I imagine respondents would say that it's in the interest of the public health, but I think that asserted interest flies in the face of the medical consensus that's really at play here. All the medical associations, and I see my time has expired, and I'll finish the question.
You may.
Flies in the face of the medical associations who have a consensus on this topic. So because Senate Bill 1 discriminates based on sex, it is subject to intermediate scrutiny in which it fails. The act is unconstitutional, and we respectfully ask this court to reverse the 14th Circuit's decision.
Thank you, counsel. Counsel for petitioner on the second argument.
Good evening, Mr. Chief Justice, Your Honors, and may it please the Court. My name is Tobey Condon, and I represent the petitioners, the transgender minors, and the parent petitioners in this appeal. Our clients succeed in their petition today because the Court of Appeals made a misstep and failed to recognize that the parent petitioners have a deep and ancient right and duty to direct the medical care of their children and make medical decisions to address those ailments. And thereby, the Court of Appeals failed to apply strict scrutiny to the act under consideration.
Counsel, would you agree that you've got a bit of an uphill battle here today in light of the court's decision in Dobbs versus Jackson itself?
I would say that Dobbs doesn't close the door entirely to what the petitioners are seeking here, and indeed there is a litany of cases decided by this court and district courts that would support the parent's fundamental right to this treatment. I would turn.
Absolutely. There's limitations, there not.
There are limitations, and there is case law that outlines those limitations. For example, in Hickett v. Brown, the D.C. Circuit Court addressed this same balance of rights and interests at play and said that the state does have some limitation to regulate these treatments, but that it has to be in conjunction and in conversation with overwhelming medical evidence. However, the state here today is in total opposition to the evidence and the universal consensus of the American Medical Associations that say that this treatment is beneficial. In addition, no circuit court that has ruled on these issues has ever determined that these treatments are without benefit or that banning these treatments would be beneficial to those who receive them.
Can you give examples of sex gender discrimination that have been held to be unconstitutional?
Would you mind repeating the question?
Can you give me examples of sex gender discrimination that has been held unconstitutional?
Your Honor, I would point to cases where the Supreme Court, this court, and district courts looked at the language of the act and found that under the heightened scrutiny test, the state's interest was not, the state had the onus to determine that that the act that they were passing was substantially related or bear a strong relation to an interest, and that the state failed to supply that interest, such in the case of discriminating against private employees or employees of municipalities for the way that they express their sexuality or their sexual orientation. It's all right, I would like to turn to the fact that courts in this nation have grappled with the medical application of this right already, and have laid out a pathway for this court to follow that has recognized that parents shall be liable to make medical decisions for their children and to seek advice from professionals in doing so, while permitting some state regulation. However, as I've said, the necessary conditions of that regulation are totally absent here, as the state legislates in opposition of the overwhelming medical evidence and unanimous circuit court findings in support of these treatments, and recognizing the risks of banning them outright. Given the presence of this fundamental right, the onus is entirely on the state of Red to show that the infringement is narrowly tailored to serve a compelling state interest.
Mr. Condon, what is the particular fundamental liberty interest that's at stake here?
The right of the parents to recognize illnesses in their children and to seek medical treatment in conjunction with medical professionals to treat it.
The parents' right.
The parents' right.
Any others?
I would also point to the fact that medical professionals have just as ancient of a duty to do no harm, and that the recommendations that they make for treatment have to be in the best interest of the patient. And this is always held by this court to be a decision that's made in conjunction with parents, patient, and the doctor, and that the parent has recognized a medical condition in a child.
Is there unanimity among the medical profession that this care is beneficial to children suffering from gender dysphoria?
Yes, I would look to a number of authorities, including the Endocrine Society, the World Professional Association for Transgender Health, who in turn have informed the AMA, the APA, the AAP, and countless other chief authorities in this nation on the subject, who have adopted a shared set of regulations over when this treatment is deemed to be necessary and beneficial, and the steps that doctors should take in conjunction with providing informed consent to
Sorry,
parents.
but I didn't ask whether there was a large number of physicians that have come to this conclusion. I asked if there's unanimity.
While there isn't total unanimity, the DC Circuit Court ruled in Pickett v. Brown that there needs to be a broad or overwhelming consensus. And here, there's an overwhelming consensus that this treatment is beneficial. There is very little, if any, evidence that the state can provide that this treatment isn't beneficial, and no circuit court has ever held that this treatment isn't beneficial, or that to take this right away from the parents and doctors would provide some benefit to the children.
Mr. Condon, if this law is passed, couldn't parents take their children out of state to receive this treatment? Parents would have the ability and the money, whereas parents who don't, their kids would not be able to treatment. Is that not a result of this law?
Well, it would be a consequence of the law that the petitioners would have to spend money that they may or may not have to seek treatment elsewhere. And I would look to the fact that 20 states in recent years have passed laws on this to say that, if that is...
Basically, rich parents can take their kids out of state, while poor parents have to deal with the law.
Essentially, and I would say even those with money and resources, the specific regimens of these treatments would require parents to quite often drive their children out of state, hundreds of miles in some circumstances, to states that have clinics, that can provide this treatment on a weekly or monthly basis. And finances aside, it's an incredible burden on the parents and the children, who are already dealing with emotional issues relating to these treatments and the illnesses that these treatments are meant to address.
So are these decisions that a child is making with the parent, would you argue, or it's the parent's decision separate from the child? And what I'm getting at is that we have laws that a child or a person cannot vote until they're 18, can't drink alcohol until they're age 21 because of the maturity level. They can't make, brain development. Studies show that brain development really doesn't stop until age 26. And yet we have children at 13, 14, 15 who want to have some type of surgery for hormone treatment. How do you respond to that?
Again, Your Honor, I would say that this is a decision being made in conjunction with all three parties involved, and that a mere assertion by the child that they desire this treatment is insufficient to receive that treatment. The medical professionals who are being advised by this broad consensus of American professional associations would turn first to other methods of social transitioning, anything from using preferred pronouns and changing grooming standards to vocal therapy. But in the case of every one of the petitioners in this case, that was insufficient to truly address the problem, and mental health issues continued afterwards. And the medical professionals found that it was only when the social transitioning was yoked with these medical interventions that the children petitioners in this case truly received the benefits that they desperately needed. And to follow up on that, Pickup did deal with a case in which parents were seeking medical treatment for their children, which the children themselves did not necessarily want. It was essentially shock therapy to cure, as the parents would say, their children's sexual orientation. And the broad medical consensus there was that these treatments are unhelpful, that they're in fact harmful, that they provide no benefit, and the court looked at that medical consensus in determining that the parents in that case were not able to force this treatment upon their children.
Would the act prohibit, for example, if a female had an extra breast, a third breast? Would the act allow a parent to choose to have that removed before age 18?
The specific language of the act deals with discomfort that arises through incongruity with the minor's sex assigned at birth. There could be an argument made that this act would ban such treatment as the state relies on a traditional notion of what sex and appreciation of that sex through puberty looks like, and given the role of secondary sex characteristics like breasts in puberty, the state may say that under the act that the child has no right to that surgery at all.
But doesn't the act actually allow that? Because most women have 2 breasts, they don't have 3, so would that not be removal of the 3rd breast in conformity? So would not the act actually allow that?
Again, the language of the act doesn't point specifically to the issue here, but it's the belief of my clients that this act is overbroad in its control over the parents and the minors in medical decisions and in treatments that are otherwise perfectly acceptable to parents of cisgender children. A child who feels that he's not tall enough and is uncomfortable with his height can receive testosterone, as my co-counsel said, but the same minor who's looking to receive testosterone to address a similar mental health condition is banned from such treatment under this act.
Counsel, how would you distinguish the act from a statute, say, that prohibits physician-assisted suicide, which has been found to be constitutional?
So this court made rulings on physician-assisted suicide in cases like Vaco and Glucksberg, but those cases dealt with rights of medicine that was found to be concerning to the state, and that the state was dealing with an affirmative right to that treatment, or a right in some cases to refuse treatment and to die with dignity, essentially. However, this court found in those cases that there needed to be other options available. In Justice O'Connor's opinion in that case, for example, she points to the fact that there's palliative care available that still provides a similar degree of treatment to the right to suicide that patients in those cases, in Vaco in particular, can receive large doses of painkillers, in effect providing the same treatment. Here, however, the other tools left in the tool chest are insufficient, as I've said, to deal with this issue at hand, and would not be the complete treatment plan that the doctors have often had access to in dealing with medical issues. And so I would return again to pickup, which gives us a broad range, gives this court a broad. I see that I've concluded my time. May I finish?
You can finish that thought, counsel.
Thank you. This court cannot be too hasty in providing relief to these children and their parents. For these reasons and the reasons I've highlighted above, we humbly request that the court overturn the decision of the Court of Appeals and strike down this act. Thank you.
Thank you. We'll turn now to counsel for respondent, first argument.
Proceed.
You may.
Good evening, Your Honors. May it please the Court. My name is Jake Weber. Today I represent the State of Red and William L. Attorney General, on the equal protection issue of this oral argument. This case revolves around Red's Senate Bill 1, which is the Prohibition on Medical Procedures Performed on Minors Related to Sexual Identity Act, The law passed in the state of Red, restricting gender-affirming medical treatments for minors with gender dysphoria. SB 1.
What is the important governmental objective of this act?
Certainly, Your Honor. So while petitioners have cited specifically Section 6833-103A of Red Code, which is part of the Act, they claim that the only interest that the state asserts in the Act is to uphold stereotypes or expectations of gender. In reality, this bill is focused on child safety. I would point to Section 6833-101B, M, and E, and G.
Based on what authority? Medical evidence?
Yes, Your Honor. So Section B refers to health of the child. M is protecting from physical harm. And then B, E, and G is the use of off-label or experimental
But aren't
medication.
many of these treatments already being used for children that have precocious puberty?
Yes, Your Honor. So puberty blockers have been prescribed for people who are experiencing early onset puberty and things of that
And
nature.
then there's no negative side effects when their puberty has been blocked so that they can be of the type of child that we expect them to be, right? It's not permanent.
Correct, Your Honor. That there are no negative consequences to doing that for someone who is experiencing early onset puberty, for instance. However,
Doesn't that mean that the transgender kids are necessarily treated differently by the statute?
No, Your Honor. I'd like to turn back to the previous Justice's question real quick, and then I will address yours here. So, in reality, the interest of the state here is to protect the children. Studies show that there is a decreased bone density. Yes, but it is also
That they're right and their obligation to do, because if they don't, doesn't the state take them away?
yes, in extreme circumstances, but it's also the job of the state to be able to protect its citizens, which is what Senate Bill 1 is here.
Protecting the child from what?
So, protecting the child from a decreased bone density, long-term infertility. There are also high risks of different illnesses such as cancer, things along those lines.
So do we let kids go to skate parks then? Can't they go to mountains?
Yes, Your Honor.
So why are we allowing that?
The difference here is that the use of these medications is, in essence, off-label and experimental in nature.
I thought that they aren't off-label to be used for kids with precocious puberty.
Certainly. So in the instance of someone who has early onset puberty and is receiving puberty blockers to suppress their puberty, that is on-label utilization. However, if we are looking at someone who is looking to transition from male to female and they want to halt their male puberty process, that is an off-label utilization for the drug. Same thing for
Girls can use it.
No, Your Honor, it would be the same application. If someone is looking to transition from female to male and they have puberty blockers block estrogen, it would still be an off-label utilization for blocking estrogen production and then later expecting to have
I
testosterone.
thought one of the state's concerns is that there's a permanent, lasting, non-reversible.
Absolutely. That is one of the state's concerns, Your Honor.
But you just said before that they're not permanent or long-lasting. That blockers, once you stop using blockers, you return back to the
Let me clarify my statement then. Sorry, Your Honor. The reference that I was making is that someone who's looking to transition as a minor may take puberty blockers anticipating later on to take the hormone of the gender they are looking to transition to. So someone who is female transitioning to male may take a puberty blocker to prevent estrogen production, and then later on in their life take testosterone supplements in order to be able to complete the transition fully.
later on, like when they're over 18.
Correct. They may do so when they are over 18. So additionally, I'd like to point to some of the case law that supports the state position.
I just need to ask you a question. How can you say that the legislature knows better than the parents and the physician what is in the best interest of the child?
So while the legislature is not made up of doctors, the legislature's job and its role in our government is to be able to have debates on policy matters such as this. And so at the end of the day, whenever we're looking at a law that is not discrimination based on sex and we have a rational based.
I want to stop you there. It feels like you're getting sort of caught in a little bit of a bind. We don't disagree that if two children that look very, very similar, both identifying as male, walk into a physician's office, and they both want puberty blockers. They both present as male. They both want puberty blockers. The physician has to fundamentally important question before you can decide under this law whether it's permissible to give those puberty blockers. Am I correct about that?
Yes.
What is that fundamental question?
That fundamental question would be, first off, is this patient presenting with early onset puberty? And if not, then potentially, are you intending to transition with this?
Actually, it seems like there's an earlier fundamental question the physician has to ask. When two children walk into the physician's office wanting this care, the first question they have to know whether they can provide it without breaking the law is,
Are you biologically male or female? Right. And Your Honor, that's why at the end of the day, this is not a difference based on sex. It's a difference based on treatment and prescription medication.
one of those children was born biologically male and one was born biologically female. Is that not a discernment based on sex?
Simply, I would say no, Your Honor. A reference to sex in the law is not the end-all, be-all of
It's not a reference to sex in the law, it's a reference to sex in the physician's office at the time that he's making the decision about whether to administer the care. Is that not discrimination based on sex?
Your Honor, no, because similarly speaking with pregnancy, for example, with dogs.
How can the answer be no? You've got two children, both wanting the same care. One was born biologically male, one was born biologically female. That fundamental question has to be, which of these children can I give this care to? The physician cannot accurately know what the biological sex was at the time of birth. How is that not discrimination based on sex?
So that would not be discrimination based on sex because it does equally apply to all minors. So if you look at something cases such as Reed versus Reed, or something like Vaca versus Quill, in which we have equal applicability and we have wide breadth, the law itself does not require only male minors to not receive care or only female minors not to receive transgender treatments. It is all minors in and of themselves.
The law is regulating the reason for the treatment, not that the treatment is harmful, is what I'm hearing.
And to that, Your Honor, I would disagree. And I would point back to the actual statute. There are 3 different references to the safety of a child or a potential experimental drug or off-label utilization that are made in the statute. And again, that's sections 6833-101B, M, E, and G is where those 3 different references come from in Red's code. There's only one reference to treating discomfort or distress with expressing one's gender, and that's at 6833-103A. And so the state does have an interest that they are clearly outlined in the statute, that is the protection of the minors.
Does the state agree that these children are suffering, have pain, are under psychological stress? Does the state agree that that's legitimate?
That is what the studies do show, Your Honor. And to that,
So by preventing them having treatment, you're forcing them to continue to exist in this status of discomfort, pain, of high levels of stress.
the state will disagree with that, Your Honor. The reason for that is the state is not banning the ability to be transgender or express yourself as a different gender. The state is focused on protecting the health and safety of minors who are
So they
subject to.
can't get the treatment, how do they get the treatment?
Well, just because the medical treatments are off the table does not mean there are other instances. The opposing counsel even referenced there are vocal therapies, cognitive behavioral therapy
I think
practices.
counsel also said one of the petitioners, the plaintiffs, spent 2 years in psychological treatment with no relief. So we're going to continue to have until they're 18 to suffer this stress and this injury and this pain? That seems cruel.
Your Honor, I do admit that the specific situation of that plaintiff is not desirable by the state. However, we do have to look at, is this in the state's authority to be able to regulate the medication? The answer to that question is yes.
So what if you have a child that has done everything but medical procedures and is suicidal, and there's been several attempts at suicide? Is there an exception to treating that child?
In the statute as it's currently written, no, there is not.
How is that in the best interest of the child?
So when we look at, again, the statute, it may not be in the best interest of the child in an instance that is such an extreme scenario as that.
Isn't that ludicrous that a physician physician's expertise for that child is trumped by the legislature who has no medical background as a whole.
I do understand that that doesn't seem to purport very well, but the role of the legislature is to be able to regulate medical treatments
Do
and
you
as
agree
long
that the statute is rather binary in its approach here? Which is to say, there could be more modern approaches to regulating care of this sort. So in the instance my analyst cited, the state might acknowledge that it has an interest in protecting the integrity of that child and in trusting the decisions of the parents of that child and the physician of that child. But perhaps in other instances where there have not been attempts to get psychological care or other forms of treatment before turning to hormonal or surgical treatment, there might not, the state might have an interest in regulating the care. Is there not a more nuanced approach here that the state could have taken?
I do not think there's a more nuanced approach, and the reason for that, very briefly, because of time, I'm also going to address intermediate scrutiny with this question here. So when we look at intermediate scrutiny, it has to be an important government interest, and it has to be substantially related to achieving that government interest. What we have here is not a ban on being transgender or expressing a different gender identity from who you are. The ban here is specifically on medical treatments that have scientifically been shown to have potential for harm to be caused to the child. Because of that is the reason why. I see my time has expired.
You can finish your thought.
Thank you, Your Honor. So because the difference here is we're not banning transgender identity. If that were the case, we would absolutely fail, even rational basis. But what we're doing here is specifically banning experimental treatments that have the potential to cause harm to a minor. And therefore, it is more narrowly tailored than a blanket ban on transgender expression. The state of Red Senate Bill 1 does not fall afoul of the 14th Amendment's Equal Protection Clause, and therefore I ask you find in favor of the state and uphold the 14th Circuit's decision. Thank you.
Thank you, counsel. Counsel for responding to the second argument.
May it please the court. My name is Gabe Pirtle, and I represent the respondents in this appeal. The Court of Appeals' opinion is right. We ask that you affirm their decision because the state's argument that the REDS Act does not violate the Due Process Clause and does not require strict scrutiny is grounded in the well-established principle that there is no deeply rooted tradition preventing governments from regulating medical treatments.
How long does it take, counsel, for a tradition to be deeply rooted? Is it 200 years?
There's no exact qualification.
Could it be 100 years?
It could very well be 100 years.
Could it be 80 years? Or 50?
Well, there's no exact year cutoff. In this case, the state argues that there's no deeply rooted tradition that supports a constitutional right for parents to obtain any medical treatment they desire for their children.
But there is fundamental right for parents to get treatment for their children who are suffering from illness. Would you
Yes.
agree with that?
Yes, Your Honor, there is a fundamental right.
And does the state agree that gender dysphoria is a recognized illness?
Yes, Your Honor.
So why can't parents who have a fundamental right to have their children treated for this illness that you agree to have that?
Your Honor, while parents generally have the right to direct the upbringing and medical care of their children, this right is not absolute. The Supreme Court's decision in Parham v. JR is instructive on this point. There, the court addressed the issue of whether parents could commit their children to state mental institutions without significant procedural safeguards. The court held that while parents typically make decisions in their children's best interest, the state has a vested interest in ensuring that those decisions do not harm the child.
And that was decided because doctors need to be involved in that process to decide whether or not those children need to be institutionalized, correct?
Yes, Your Honor.
Aren't doctors involved here with the gender dysphoria?
Well, over the past several decades, the medical associations have dramatically shifted their views on gender-affirming care, and particularly for minors. Back in the 1960s and 70s, treatment for gender dysphoria primarily involved therapy and social conversion.
Isn't that because there's been an evolution in the understanding of how hormonal care can assist individuals with
shift, yes, but notably these changes, these gender-affirming drugs have not been approved by the FDA and other organizations for treating gender dysphoria.
Have plastic surgeries been approved by the FDA for minors?
No, Your Honor.
And are parents allowed to permit their children to have plastic surgery that affirms their gender?
Yes, as held in Abigail Alliance, off-label use of drugs is legal only in the absence of state regulation. So as long as there is no regulation by the state against plastic surgery, then that would be permitted. But given the REDS Act prohibits such off-label use in gender-affirming care for minors, it is within the state's authority to restrict these treatments based on concerns about their safety and long-term impact.
And like the fundamental right for parents to decide about medical care for their children, why isn't, and this law affects that, impacts that, why isn't there a higher level of scrutiny like the claim there isn't? Why shouldn't there be? It's a fundamental right of parents we can talk about.
Because for there to be a higher level of scrutiny applied, this court today would have to hold that there is a due process violation. And while parents generally have the right to direct the upbringing and care for their children, there's numerous instances to prove that this right is not absolute.
Well, it's not absolute, but you still, because it's a fundamental right that you're impacting, doesn't that cause there to be a heightened level of scrutiny?
Your Honor, we would argue that there is no deeply rooted tradition, thus requiring strict scrutiny that prevents governments from regulating.
There have been parents for thousands of years, and that right has existed for thousands of years. How much deeper rooted can it get?
I'm not arguing that that right doesn't exist, just that it's not absolute, and it cannot trump the state's interest in protecting the welfare of children that has long been established by this court as well. For example, in Prince v. Massachusetts, the Supreme Court acknowledged.
Does the state regulate experimental cancer treatments for children when they're at the end of their lives and have no alternatives left, but experimental cancer treatments? Does the state assert the inability of parents to provide that care for their children?
The state is allowed to regulate any off-label or experimental use of treatments.
Isn't this really just a political statute?
Your Honor, no, this is not just a political statute. We've seen over 20 states purport laws similar to the one in question. And the state's interest in protecting the welfare of children has been repeatedly upheld in cases where parental decisions may place a child at risk. This is particularly relevant in areas of medical uncertainty, as in this case where the risks and benefits of
Parents allow their children to do things at a high degree of risk on a daily basis. Skate, play football, go hang glide, jump out of airplanes. Aren't those things that are high degree of risk with significant injury? And they're allowed to make those decisions.
Your Honor, those decisions are different than the ones at question because this use of this medication has long-term irreversible effects that...
Partners said they weren't reversible. They said they were reversible.
Could you repeat that? I'm sorry.
Mr. Weber admitted that the treatments were not all irreversible. I'm not talking about surgery. The hormone treatment and puberty blockers, you stop those, things go back to normal. He agreed to that. Do you disagree with what he said?
All effects of these treatments are not necessarily irreversible or reversible. For example, the effects that this can have on fertility can be long-lasting into a child's adulthood, and that's why the state has the interest in protecting the welfare of the children who may not understand the long-lasting impacts of these decisions and are not in a place to make those decisions for themselves.
Sorry. Go ahead. I'm going back to my colleague's questioning earlier about the
Changing,
And how is the state balancing that? Why is the state diminishing that interest in protecting the child versus accentuating the interest of the state in maintaining, in keeping you from accessing this care?
Your Honor, we understand that changing the sex characteristics of a child's body carries risks in either direction. But states may exercise caution in these circumstances, with some focusing on the near-term risk of increased symptoms of gender dysphoria, and others focusing on the often irreversible risks of providing such care to a minor. The legislature is much better suited to this sort of cost-benefit analysis.
In that cost-benefit analysis kind of way, is it more common that that youth that undergo transgender care of this sort wish to reverse that care, or is it more common that they wish to continue with that care once they reach the age of majority?
Your Honor, I would say that it is more common for them to not wish for the reversal. That doesn't diminish the long-term impacts and irreversibility of those who do end up wishing to reverse, or wishing they haven't.
So in that cost-benefit analysis, it sounds like the state is having an interest in the minority rather than an interest in the majority of the people who would be affected by this regulation.
Well, Your Honor, anyone who experiences sorts of mental anguish or need for therapy that gender dysphoria, this treatment could cause, would have other ways of alleviating those concerns. But a minor who, at a young age, had received hormone therapy or puberty blockers has no recourse for down later in life for going through
Everything
normal
else has failed. Everything else has failed. The child is suicidal, and again, as many attempts at suicide, and there's nothing else that can be done but hormone treatment or surgery. Do you agree that it's not in the child's best interest?
Your Honor, in a situation that is as dire as that one, perhaps it would be in the best interest of that specific child, but for the
So what happens to the physician that treats that child then? That physician has a choice between breaking the law or saving a child. What happens?
the physician could, the physician has numerous other options they could pursue, such as social conversion therapy, as well as numerous other forms of
But those
therapy.
have failed. They have failed.
Counsel, let me phrase it a different way. Is this court's job to pass judgment on whether we think that the state's legislature's act is a good idea, or is our job to decide whether it is constitutional?
The court's job is to decide whether it's constitutional. And in this case, the state's argument does not violate, that the act does not violate the Due Process Clause, is one that is based on the century-long right for state and federal governments to the authority to regulate health and welfare, which includes medical treatments. And this often restricts individual or parental autonomy in the interest of public safety and
Does the
protection.
state prohibit all treatments that have not been approved by the FDA? In other words, does the state prohibit all non-label treatments, off-label treatments?
Your Honor, I do not know whether the state prohibits any off-label use of any drugs. I see my time has expired. May I briefly conclude?
You may.
The state maintains that the REDS Act is a valid exercise of its authority under the Due Process Clause to regulate medical treatments, especially those that are experimental or carry significant risk for minors. For these reasons, we respectfully request that you refer the Court of Appeals decision. Thank you.
Thank you, counsel. Petitioners have reserved time for rebuttal. First argument, rebuttal.
Thank you, Your Honors. In cases where a child's life is at risk, respondents admit that a child deserves this treatment. But this act would deny a child treatment when it is necessary to save their life. That is not public health, it's execution. Discrimination based on sex is not dispelled by equal application, as respondents claim. Refusing a transgender male and a transgender female, when they come into the doctor's office, this care is the equal application principle that Loving v. Virginia blew up. Treating two groups with equal discrimination does not make a practice free of invidious discrimination. It's just more discrimination. Judges highlighted, or Your Honors highlighted, that the effect that the minors would want to continue this care. The minors would want to continue this care. Respondents claim that most would not. That is patently false. In 99% of cases, minors would receive this care again. And respondents never provide convincing medical or scientific evidence to support their claims, but phony interest in caring for minors' health.
Aren't you, counsel, aren't you just making the same argument, asking this court to disagree with the state's policy as opposed to decide whether or not the act is constitutional?
Well, the court strikes this law down on due process and equal protection. We're asking this court to rule that the act is unconstitutional. It's unconstitutional on equal protection, which the respondents violate here by using the equal application principle. They say that if discriminating against one group isn't okay, we'll just discriminate against another group. We'll discriminate against transgender males and transgender females. That's not allowed under Loving v. Virginia. Treating two groups with equal discrimination is still just discrimination. The respondents cite the FDA.
Is this law political?
This law is political.
Tell me why it is.
It's political because of the interest, and I see my time's expired. Can I answer your question? The interest that Red asserted was one in prohibiting transgender youth from conforming to a gender stereotype that Red did not agree with. Not that it's in the best interest for their health, but Red State simply does not like it. Thank you, Your Honor.
Thank you, counsel. All right, thank you everyone for your arguments. Court will take this matter under advisement and we will be adjourned.
All rise. Be seated. All rise. Be seated.
All right, we're back in session. I suppose we'll break the third wall here a little bit. I want to tell you all congratulations, and you did a really fine job. I think we have some more feedback that we can give you in a little bit more detail, but I wanted to say at the outset, everyone did a really fine job. A bunch of folks up here that have seen a lot of lawyering over the years, and yours honestly would stand up with a lot of people way more experienced than you are in these sorts of things. So you should all be congratulated. You did a good job. As the judges of the Moot Court this year, tasked with coming to a deciding on who the top advocate was. It was a difficult decision because all of the advocacy was very good. But at the end of the day, this court decided that our top advocate this year was Jake Webb. And if we could have the rest of our advocates come forward, we'll begin with Elijah Wetzel. Tobey Condon. feedback as well. I thought there were certain things that everybody did a really nice job with. I'll point a few of them out. I don't want to take up all of the time either, let all of the judges give you some personal feedback. But I thought everybody did a reasonably good job. When they were hit with a question, they were able to answer the question and get back to their outline. Elijah, I thought you did an exceptionally good job of that on the very first question you got. And the first one on the day is always the toughest one, in my opinion. So I thought you did a nice job with that. But really, everybody did a good job with that. And it's a difficult skill to be smooth with that and to be able to return to your argument after you're hit with a question that maybe you expected or maybe you didn't expect. So you all spoke at a very good pace. After 30 years, that's still a problem for me sometimes. So the fact that you all kept at a level pace and kept that throughout your arguments, I thought was really good. You were well spoken. You obviously had prepared a lot, put a lot of time into the arguments, and you thought on your feet really well, which that's not easy to do either. So overall, really good job. I don't have too many things that I could really come up with to tell you to work on.
Gabe, you got the brunt of our questions. We got relaxed up here. We just peppered them. You did a really great job of handling it. I mean, I know it's difficult. You want to say something, the things you want to say, but we won't let you, and that can be almost as frustrating as anything. And overall, we actually discussed this back in chambers, is that your advocacy here today is many times better than we've seen in our own courtrooms with experienced lawyers. So you should be very happy and proud of how you all advocate for, because it's top notch.
Well done for all of you. You guys did an amazing job. As you may know, there is a lawyer shortage in Indiana. I hope each one of you will seriously consider going to law school, and please call me. If you have any questions, I love to mentor students. I do it all the time. And if you have any questions, please call me in a year, 5 years, 10 years, whatever, because you all have the skills to be a good advocate. This is what I did today or tonight. This is my job on the Court of Appeals. So I was giving you the questions just like I would give to seasoned lawyers. And all four of you kept your composure. I didn't see that you were nervous. You got back on track and you were well prepared, and that says a lot. And whatever career you decide to go forward in, be prepared. You can never be over-prepared. And I hope you'll take these skills that you've learned and do something good with them, because I think you guys are all going to be successful.
Yeah, I just have a couple of things to add, but I do want to reiterate the point that each of you performed so well, even compared to seasoned advocates. Earlier today, the Seventh Circuit Court of Appeals did oral arguments at our law school, and there were real lawyers there arguing real cases in front of the Seventh Circuit. And Judge Easterbrook was, Gabe, I felt a little bit like I was channeling Judge Easterbrook, but I was asking you a lot of questions for a bit today, and maybe that's where that was coming from. But your composure in answering those questions was remarkable, especially as I was comparing it to the composure of some of the lawyers that we saw earlier today. To say that you were more in role with respect to what the role of the lawyer is, that you were playing, the role that we were playing here on the bench, more in role than the lawyers I saw in an actual oral argument today is you were, and you did a fabulous job. And that's true for all of you who took questions from the four of us. You were well prepared, you knew your role, you knew the decorum, you clearly get very well coached, but well beyond very good coaching, you clearly have done a lot of studying. And so I just want to close by remembering that when you were being introduced, Elijah, I don't know the quote exactly, but it was something like, you can never be too prepared. And it was really clear that you were all exceedingly well prepared. And for
note their participation tonight and our appreciation. We hope that they will display them in their offices and as a token of our esteem and appreciation. There is a second award that we give at the court. It is called the Floyd Artful Advocacy Prize. It honors the memory of Douglas B. Floyd, a Hamilton County lawyer remembered by his colleagues as an artful advocate of causes he believed in. The winner is to be not only a successful advocate, but also kind, tactful, and principled. As lawyers might say, our winner succeeds without scorching the earth. What we seek with this award is not only winning qualities of an advocate, but also a winning disposition, someone who can take the heat with a smile. Funded by gifts from Doug's colleagues, friends, and family given at the time of his death in 2001, Doug's wife, Lisa Floyd, and his son, Riley Floyd, Wabash 2013, established the prize in 2019. Selection is made by the faculty who organized them at court, and the award may go to any of the 4 finalists. I should add that this award is determined independently of our judges' deliberation. We're very happy to award the Floyd Artful Advocacy Prize for this school year to Jake Weber. So just a reminder, all of those who participated in this year's competition in any way, shape, or form, as a final round panelist or finalist, as a judge at any round of the competition, as a student at any round of the competition. Please come to the stage now for a couple of quick photos, and then I would invite all of us to gather in the hotel lobby for a reception. We really appreciate you coming this evening. We hope to see you again.